Good evening, everyone. Thank you for joining us in the fourth of this series of lectures in relation to human rights and the state. Tonight's lecture is in relation to police restraint and deaths in custody. I'm pleased to say that I have two guests joining me. First, Dr Nat Cary, an eminent forensic pathologist with more than 3 decades of experience dealing with deaths in custody and in particular police restraint. I'm also joined by Deborah Coles, director of the charity INQUEST, and who was a special advisor to Dame Angelini's review on deaths in custody. Both of my guests will be giving their views in relation to this rather controversial topic. I ain't welcome here no more. I walk down the street and guess who I meet? The men in blue who are supposed to defend, but instead they chose to apprehend. They slap, punch and choke me red. They won't stop until I end up dead. Oh stop, please, I can't breathe. I beg of you, just go and leave. My cries all disappear out of sight. I'll end up dead if I try to fight. His knees up against my throat. No one can stop him, they're all too remote. My God, what country do I call this? A nation where the pow pow can just go bliss. At my expense, I kid you not, I'll be beat, stepped on or even shot. This nonsense must stop, but of course it won't. All I can do is scream, please don't. As I bleed here lying on the floor, I know I ain't welcome here no more. That was a poem written by a grade 9 student from the USA, Baltimore, Adeyodele Ayula. She wrote that following the disturbances and issues surrounding Black Lives Matter last year. I can't breathe. In 2020, millions of people around the world heard these words as they watched a deeply traumatic video of George Floyd being killed by a police officer. As we all know, his death sparked mass protests against police brutality all over the United States and around the world. A lot of British people think this is just an American problem. After all, we have a softer, friendlier image with our police. Many of them still don't carry guns. If you're white, middle-class British person who's never had a run-in with the police, it's very easy to think of that concept of the British Bobby as an essentially benevolent figure. However, those of us who've been fighting for human rights for decades see things differently. In this lecture, we're going to talk about deaths following or during police restraint. Over my career, I've seen numerous cases here in the UK where people have died after being restrained by the police. A disproportionate number of those people are Black men, and a disproportionate number of them have mental health problems or were having a mental health crisis at the time of their death. In many such cases, the bereaved family has faced years of long struggle for justice, truth and accountability after their loved one's death. Many people assume that we in the UK have less of a problem with policing than in the US because most of our police are unarmed and we have so many few police shootings. But according to the charity INQUEST, 1,160 people died in police custody in England and Wales between 1990 and 2020. That was out of a total of 1,777 police-related deaths. So we can see that in England and Wales, it is custody deaths, not shootings, that account for the vast majority of deaths at the hands of the police. This is a fundamental problem with British policing, and we cannot remain silent about it. Positional asphyxia. In December 1996, I was instructed to represent the family of Wayne Douglas. This was my really first big case, and the second involving a death in custody following restraint by the police. It would also be the first of several similar cases I work on involving the Metropolitan Police and many other police forces up and down the country. It was notable, for it's the first time I'd heard about the concept of positional asphyxia. And it was the first time I'd met our second speaker tonight, Dr Nat Cary. Now, I won't go into the many different types of restraint cases I have done. Deborah Coles will speak to that shortly. But firstly, let me start with some definitions. So, what is positional asphyxia, or as it's sometimes referred to, restraint asphyxia? Well, it's a medical concept, positional asphyxia. Positional asphyxia plays a role in many of these deaths involving police restraint. The science behind positional asphyxia was first identified in the 80s and early 90s. In the US, it was noticed that there was a pattern of similar deaths among people who happened to be disproportionately African American men who were being restrained by police while having mental health crises or being acutely intoxicated from drug use. For instance, in 1993, a study by O'Halloran and Newman described 11 sudden deaths of men restrained in a prone position by police officers. So, what is positional asphyxia? Well, I'm no doctor, and I have Dr. Cary here, who will explain the concept in more detail. And if I get anything wrong, I'm sure he'll put me right. But simply put, positional asphyxia or restraint asphyxia is a potential cause of death of a restrained person. It often occurs when the deceased has been placed in the prone position, namely on their front, with their hands handcuffed or bound behind their back, possibly with pressure being applied to the back. This is a common method of police restraint. In the States, it often happened in what was known as the hogtied position, which is where the hands were cuffed behind the back and the feet, the legs were brought up to the hands and handcuffed to the hands. So you had the feet and the hands restrained. When placed in such a position, the normal mechanics of respiration are impeded. Normal breathing movements are compromised and take additional effort. And any interference with the muscles of respiration can trigger this asphyxia. The diaphragm, the muscles between the ribs known as the intercostal muscles, and the muscles in the neck and back. If a person is held for a sustained period, and particularly if they're exhausted, this additional effort may prove too much and they may succumb and die as a result of a reduction in the oxygen in the blood, which is affected by the respiration. The problem is accentuated if the person has a larger body, particularly if they have a large stomach, or if they are drunk or under the influence of drugs. When a person is suffering from positional asphyxia, key signs include gurgling or gasping signs, cyanosis, in other words, the face turning blue, passivity, hypervigilance, and very significantly, verbal complaints of being unable to breathe. When I saw the video footage of George Floyd, this was not new to me. In fact, it was horribly familiar. Acute behavioural disturbance. There is also a medical concept which is related and used by pathologists. It was originally called excited delirium, but the term acute behavioural disturbance, or ABD, is now often used instead. The key signs of ABD are said to be delirium, psychomotor agitation, anxiety, hallucinations, speech disturbances, disorientation, violent and bizarre behaviour, insensitivity to pain, elevated body temperature, tachycardia, that's the heart beating very fast, incoherent speech or shouting, inappropriate removal of the clothing, and superhuman strength. ABD is a controversial cause of death. It's not found in the Diagnostic Statistical Manual of Mental Disorders, or DSM, or the International Classification of Diseases, or ICD, which are the two international standards of classification for mental disorders. It's a term that is primarily used by pathologists rather than psychiatrists. And this is primarily used in the context of restraint deaths. A comprehensive review carried out in 2015 by forensic psychiatrist Dr. Maurice Lipsitch cast doubt on the idea of ED or ABD as a cause of death in its own right. So we can see there's a lot of debate in the scientific community about whether ABD can stand as a cause of death on its own. This debate is often aired in inquests into police restraint deaths, with different pathologists putting forward different views. At times, the finding of ABD can be used in an attempt to exculpate the police officers involved in the restraint by suggesting that the deceased would have died anyway. But as I say, the science behind this is extremely controversial. Later on, I will be handing over to Dr. Cary to talk about the medical and scientific concepts involved. But what everyone agrees on, however, is if a person is seen to be suffering from signs of ABD, it is an acute medical emergency and they require urgent medical attention. And in those circumstances, physically restraining them is extremely dangerous. Anyone restraining a person with these symptoms ought to be aware that there is a high risk that they might die. Let's look at restraint deaths in the UK. In 2015, the then Home Secretary, Theresa May, commissioned a review of deaths in custody, including Black and ethnic minority people who die in custody. This was done by Dame Angelini, the former top prosecutor in Scotland. Dame Elish published her report in 2017, and I quote the following from her executive summary. This report argues that police practices must recognise that all restraint has the potential to cause death. Recognition must be given to the wider dangers posed by restraining someone in a heightened physical and mental state, where the individual system can become rapidly and fatally overwhelmed. Currently, there is no consistency of training in restraint techniques across the 43 police forces in England and Wales. There should be mandatory and accredited national training for police officers in restraint techniques and supervision of vital signs during restraint, with appropriate refresher training courses for officers. There should be a national consistent approach to the use of force. In addition, the ability to de-escalate circumstances which may lead to physical or violent encounters should be paramount in the skill set for individual officers. National police policy, practice and training must reflect the now widely evident position that the use of force and restraint against anyone in mental health crisis or suffering from some form of drug or substance-induced psychosis poses a life-threatening risk. End of quote. I would agree with those recommendations, but I would question whether they are enough. More training is an easy answer, but we've had decades of call for more training, and yet the same things keep on happening. I know this is something that Deborah Coles will touch upon when she addresses us. Are we holding the police to account? Well, that brings me to a discussion on what is needed to establish criminal liability for these deaths. As established by the case of Wilkinson, a verdict of unlawful killing can only be returned if the killing amounted to murder, manslaughter, or infanticide. It's not sufficient that the killing was legally wrong in some other way. Previously, the standard of proof to secure an unlawful killing verdict in an inquest was very high. It was beyond a reasonable doubt, the same as in criminal cases. But that changed very recently last year in a case called Morn. The standard of proof for an inquest now is on the balance of probabilities, or more likely than not. This is the lower civil standard of proof. Perhaps this will mean that there will be more accountability in inquest than previously, but we will have to wait and see. There are three principal types of unlawful killing that are relevant for our purposes: murder, an unlawful act, manslaughter, and finally negligent manslaughter. Now, I'm not going to be looking at murder in the context of this lecture, because fortunately, I have to say that during the nearly 3 decades that I've been doing restraint cases, I've not seen any evidence of a deliberate killing by a state agent intending to kill. So I will only briefly look at manslaughter. So let's look at the first type of manslaughter. Unlawful act manslaughter. This is where an individual could be guilty of this category of manslaughter if they intentionally do an act which is unlawful and dangerous, which inadvertently causes the death. That's the case of DPP against Newbury in 1977. It's not necessary to prove that the unlawful and dangerous act was aimed at any person, or in particular the person whose death it was caused. Neither is it necessary to prove that the defendant knew that their act was dangerous or unlawful. For the act to be unlawful within the meaning of this rule, it must be criminally, not merely civilly wrong. As for dangerousness, this is to be determined objectively. The act must be such that all sober and reasonable people would inevitably recognise it must subject the other person to at least the risk of some harm, even if not serious harm. In other words, to summarise the elements of unlawful act or involuntary manslaughter, they are: you need an unlawful and dangerous act which results in the death of another, which was committed intentionally by one or more persons if they act together in a joint enterprise. The second type of manslaughter is gross negligence manslaughter. This manslaughter is very different. As Lord Mackay, Lord Chancellor, stated in the landmark case of Adamarco, where he set out the basic ingredients of gross negligence manslaughter, you need the existence of a duty of care based on ordinary principles of negligence owed to the deceased person, a breach of that duty of care, a risk of death, not just the risk of serious injury, and that was reasonably foreseeable consequence of the misconduct, and the breach must have caused the death, and having regard to the risk of death involved, the conduct must be so grossly negligent so as to be condemned as a serious crime. The ordinary principles of negligence apply to determine whether a duty of care was owed and whether it was breached. In accordance with the principles of negligence, the duty owed by a professional is to exercise reasonable care and skill in a diligent and competent manner of a professional of the same rank within the same specialisation. The fact that an individual did his or her incompetent best does not negate the existence of a breach of duty of care that is owed. Whether the defendant fell below that relevant standard is to be assessed objectively. As regards causation, I address this in a moment. In summary, it's for the jury to assess and consider all the evidence and to conclude whether or not the standard amounted to the criminal standard and whether that standard is met. That includes looking at expert evidence. Where the misconduct was so grossly negligent, the guidance as to the meaning of gross negligence can be found in the case of Misra. There, the Court of Appeal explained the gravity of the conduct required for gross negligence manslaughter, and they approved of Mr. Justice Langley's description as follows, quote, "Considering the conduct of each doctor, I think you will find it most helpful to concentrate on whether or not the prosecution has made you sure that the conduct of whichever one you are considering in all the circumstances you've heard about, and as you find them to be, fell so far below the standard to be expected of a reasonably competent and careful senior house officer that it was something in your assessment truly was exceptionally bad and which showed such an indifference to an obviously serious risk of life, and such a departure from that standard to be expected amounted in your judgment to a criminal act or omission, and so to amount to the very serious crime of manslaughter, end quote. Where the jury concluded that the conduct of each medical professional in the course of performing his professional obligations to his patient was truly exceptionally bad and showed a high degree of indifference to an obvious and serious risk, this was considered to be sufficient. But whether the negligence should be characterised as gross is supremely a matter for the jury. This is not a question of law, but one of fact, and for the decision in the individual case, and that's the case of Adamarco. So it's clear that such quantification of fault is purely a matter for a jury. As Mr. Justice Jackson said in the case of Dawson at paragraph 44, quote, "I do not accept this submission that those breaches could not possibly amount to gross negligence. In my view, it was preeminently a jury question whether or not those breaches were so serious to amount to a criminal act." In Adamarco, Robert Mackay stressed the role of the jury in making this assessment. The coroner was correct in the present case to leave the jury to consider whether or not those various possible breaches amounted to gross negligence. So the big question is, are we doing enough? Who holds the police to account? In my previous lectures, I've talked about the inquest process, its successes, its failures, but even where an inquest does return a verdict of unlawful killing or a narrative verdict, which is highly critical of the police, what happens next? As I said in my first lecture, as far as I'm aware, there's never been a successful prosecution of a police officer for murder or manslaughter in relation to a death in custody. We need to ask ourselves this: out of more than 1,000 deaths in custody since 1990, can it really be said that none of them would have justified a manslaughter conviction? That's not to say that a criminal conviction is the only way of holding the police to account, but we have to ask ourselves is whether the system truly values the lives of the people who are killed by police. Aside from the criminal courts and the coroners, the other institutions whose role it is to hold the police to account include the Independent Office for Police Misconduct, formerly the IPCC, or the Independent Police Complaints Commission. Yet, the families of victims often do not feel satisfied with the IOPC investigations. As the Angelini review found, the IPCC, as it was then known, does not always truly feel independent of the police or of police culture. The review found that investigations were sometimes undermined by police officers involved in the death being allowed to confer in the aftermath of the death. And the review also highlighted the delays in such investigations and CPS, that's Crown Prosecution Service, decisions that they make can leave families in limbo for long periods of time. My own experience has been that police disciplinary processes are often inadequate and that the views of the bereaved family are often sidelined. However much training we give the police culture will not change unless individual officers who use unnecessary and disproportionate force are held to account. That brings me to the elephant in the room, race and restraint. As the Stephen Lawrence inquiry found, quote, "Taking all that we have heard and read into account, we grapple with the problem. For the purposes of our inquiry, the concept of institutional racism, which we apply, consists of the collective failure of an organisation to provide an appropriate and professional service to people because of their colour, culture, or ethnic origin. It can be seen or detected in processes, attitudes, and behaviour which amount to discrimination through unwitting prejudice, ignorance, thoughtlessness, and racist stereotyping, which disadvantage minority ethnic people. It persists because of the failure of an organisation to openly and adequately recognise and address its existence and causes by policy, example, and leadership. Without recognition and action to eliminate such racism, it can prevail as parts of the ethos or culture of the organisation. It is a corrosive disease. In July of last year, 2020, in Council magazine, I said this: "It's a flawed and outdated view on racism to believe that the racist is an individual who consciously does not like people based on race and is intentionally mean to them. Such a definition is a deflection which protects the system. When our profession recognises that racism doesn't necessarily come from individuals, doesn't need to be conscious, and doesn't need to be intentional, we will be moving in the right direction. Racial injustice and racism isn't a simple binary question. The racist needn't be bad, ignorant, bigoted, prejudiced, or old. The non-racist isn't necessarily the good person, educated, progressive, open-minded, or fair-minded, well-intended, or young. This discussion goes well beyond this. It's important to realise there appears to be a relationship or correlation between these restraint deaths, mental illness, and race that cannot be ignored. I think Akala in his book Natives summed it up right when he said that, quote, "Despite much seeming and some very real progress, public discourse about racism is still as childish and supine as it ever was. Where we do discuss race in public, we've been trained to see racism, if we see it at all, as an issue of interpersonal morality. Good people are not racist, only bad people are. This neat binary is a great way of avoiding any real discussion at all," end of quote. So what should we do? As I said earlier, I agree with Dame Alicia's recommendation that there should be national, consistent standards and training as regards police restraint. I believe that every police officer should be held to these standards and that failure to follow them should be regarded as serious misconduct. There should be no excuse for officers who use unnecessary or disproportionate force on a person experiencing a mental health crisis. But it's arguable that that doesn't go far enough. The root of the problem is that police officers are not the right people to respond to someone in a mental health crisis. In the light of the mass worldwide protests against police brutality in 2020, a lot of people have been asking big questions about policing as an institution. Questions like, what are the police for? Who do they protect? Whose interests do they serve? In the US and the UK, these questions are asked against a backdrop of a capitalist society with a centuries-long history of racism, white supremacy, and colonialism. The English legal system is not neutral, and it doesn't protect everyone equally. It was created by and for the ruling class to protect and serve their own interests. Many of our laws are designed to protect property and privilege rather than people. And ever since our modern police forces were created in the 19th century, they have been a core part of that system. This means that people like me, lawyers who work within the legal system, and activists who campaign for policy changes sometimes have very hard questions to ask ourselves. Is this system reformable at all, or can only be fixed by scrapping it and starting again? When we try to secure justice through the existing system, are we just putting lipstick on a pig? In this lecture, I'm not going to give a definitive answer to that question, but I will say that based on my experience, campaigning for legal and policy changes really does make a difference. We should not be fatalistic about our ability to improve things. In the last lecture, for example, I talked about how the Human Rights Act and the tireless campaigning of bereaved families have delivered material improvements in the rights of bereaved in INQUEST, even though there's still so much more to do. Similarly, while our society remains very racist, I have also seen real changes in attitudes to race and racism in my lifetime. But let me turn to the real experts. I'm now going to hand over to Dr. Nat Cary. Dr. Cary, firstly, I'd like you to consider whether there's anything that I've said in terms of the science that I've got wrong. Please feel free to correct me.
Well, thank you very much, Leslie, for inviting me to join you in this Gresham lecture. I'm going to be talking about restraint, and in particular in relation to stimulant drug intoxication. However, as Professor Thomas has already alluded to, the same would equally apply to people who are having a mental health crisis. And whether you're drug intoxicated or you've got a mental health issue, you're a vulnerable person in regards to restraint. The sort of drugs I'm talking about include stimulants, so amphetamine, cocaine, methamphetamine, and MDA or MDMA. And these are drugs usually taken as what might be termed uppers for a high. There's an important issue when you consider the role for the drugs. And this applies actually in any drug intoxicated individual. Just because the drug intoxication might explain death does not mean that it must explain death. As with all toxicological causes, the question is whether they died with it or of it. And this is important because it would often be blamed on drug alone if someone in one of these intoxicated states dies. It is unlikely, however, that the stimulant drug has no contribution at all, because it increases the likelihood of struggling when exhausted. And of course, most of these drugs have direct pharmacological effects on the heart. They often cause the heart to beat faster, and they may raise the blood pressure. I'm particularly concerned about aspects of restraint in the prone position, in other words, lying on the front. This has a number of effects that affect your breathing. Firstly, your chest movement may be restricted, particularly if someone applies pressure from behind. Your diaphragm, which is a sheet of muscle on either side separating the chest from the abdomen, may become splinted. I'll tell you a bit more about that in a minute. And finally, there may be an element of breath holding, whether it's part of trying to break out of a hold, as seen by weightlifters. When they're lifting a heavy weight, they may well hold their breath, or imposed breath holding. Basically, your trunk is compressed so much that you can barely breathe. So thinking about the chest compression first, there is a great vulnerability in the prone position, particularly if the trunk is being compressed. And by being compressed, I mean either hands or perhaps a knee being placed on the back of the shoulders, the lower back. Any of these effects may diminish breathing. For those of you who are concerned, this is not my abdomen. This is actually to illustrate the potential role of a beer belly on splinting diaphragmatic breathing. If you were to put this person face down, you can imagine that protuberance of the abdomen compressing the abdominal contents such that when the diaphragm contracts, it has great difficulty expanding the chest through also compressing the abdominal contents, because the abdominal contents are already compressed simply by the position and the effect of that abdominal protuberance. Breath holding, that may be imposed. In effect, when someone holds you down, it may diminish your breathing just because it's such a struggle to gain any breath, but also through struggling. So someone bracing themselves. And what's very interesting from physiological studies, and in fact, you can model it, if you have a very high oxygen demand, then a breath hold at low lung volumes, such as might occur if your chest is being squeezed, causes you to run out of oxygen very quickly, maybe 10 or 20 seconds. And of course, breath holding may be a part of being exposed to CS spray, because that's noxious, and it's not hard to understand that someone might not want to breathe that in. Now, the state of the detainee is very important. And Leslie has already talked about acute behavioural disturbance, or what is termed excited delirium. At its most severe, there may be hypothermia. The body may have a raised temperature. And this is undoubtedly a lethal state to be in, particularly if your temperature approaches 39, 40 degrees centigrade. In a typical case, those restraining may describe apparent strength and stamina. And it's a very good way of assessing how much effort the person must have been subjected to using by the fact that a number of police officers are exhausted themselves by applying the restraint. All this leads to a high oxygen demand and lactic acidosis. Lactic acid creates acidity in the blood. And basically, if you exercise muscle without an adequate oxygen supply, that creates lactic acid. That's a dangerous environment because it makes your heart vulnerable to a rhythm disturbance. And even some of the old descriptions of bad effects of restraint describe this lactic acidosis. I think it's a very important phenomenon. Exhaustion is a very important component of this dangerous state of affairs. I've already mentioned hypothermia, but of course, hyperactivity due to being in an excited state. It's important to understand that this need not be activity where you can see movement. It may be what's called isometric exercise, where the muscles are working very hard, not causing any movement, but just in resisting restraint. And of course, the component due to struggling, which inevitably will constitute a very high exercise level, as I've described, you can see the exhaustion of those restraining. Then there is a factor called post-exercise peril, when someone is particularly vulnerable after taking quite an extreme level of exercise. They don't immediately recover from the metabolic effects of that exercise. In particular, the lactic acidosis takes some time to disappear from your system. This becomes important in restraint-related deaths where there have been more than one episode of restraint. If the person doesn't have a chance to recover between one episode and another, they basically carry with them the bad metabolic effects of the first episode. So exhaustion is really very important as part of the vulnerability of this condition. So when we investigate a death following restraint, we consider a number of potential factors and whether they are present or not and how important. I've already mentioned that the struggling and the potential for anaerobic metabolism, that's metabolism in muscle that doesn't use oxygen, the danger of acidosis, but there's another danger, which is hyperkalemia. This is a rise in your blood potassium level. And we have lots of potassium within our cells, not very much within our blood. But the restraint may cause damage to muscle through extreme contraction of muscles, and this may release some potassium from within the muscle. That is dangerous because it affects the heart function. If your blood potassium is raised, that on its own can cause fatality. There's another way in which damage can be done, and that's if the muscle is directly compressed, such as through leg restraints, and you can get muscle breakdown, which is a condition called rhabdomyolysis, which, as I say, could release potassium. And anyone with sickle cell trait is vulnerable to what's called exertional rhabdomyolysis, muscle breakdown on exertion. And so it is always important to determine if someone was actually a sickle cell carrier because they have a greater vulnerability. But that doesn't explain away the role for restraint. It's just a vulnerability, as with many vulnerabilities. As I mentioned before, there are potentially pharmacological effects of stimulants on the heart, which may make a heart rhythm disturbance more likely. There's the position, and so it's important to determine from statements or eyewitness accounts what position someone was in. As I've described, the prone position is the really dangerous one. And these ingredients really are key in determining whether restraint has a role in causing death. But you can see it's very dangerous if breathing becomes impaired when you have a high oxygen demand. Basically, supply does not meet demand. A very important factor that's sometimes forgotten about is the duration of restraint. This is not something that will happen instantaneously. These are when there are a very long episode of restraint of several minutes, and there doesn't seem to be any attempt to have a way out of that. I know in the old days, in an NHS setting, in psychiatric units, I know as a matter of fact that people would go on being restrained for many minutes. And I was told by some of the people restraining they were taught to restrain until someone went limp. Well, you can see with all this dangerous metabolic background that I've described, how dangerous that is. So it's very important. I think there's a general consensus amongst forensic pathologists that in the UK, as opposed to North America, excited delirium is not a cause of death. It simply describes the drug effect on the individual. In other words, behavior alone does not kill you. So in these sorts of cases, a narrative cause of death is often a best approach because it describes the various factors without necessarily giving greater weight to one or other. And so the sort of cause of death that might be adopted would be sudden death during prolonged restraint in the prone position in association with cocaine intoxication. So when you're investigating these, it is possible to significantly diminish breathing through compression of the trunk in a prone position. Breath holding, either imposed or through the detainee's own attempts to break free, could precipitate sudden collapse, and any role for restraining causing death versus the pharmacological effects of a stimulant drug needs to be carefully weighed up. So this sort of a case is very evidence dependent. What was going on at the time of the cardiac arrest or the time of the unconsciousness? We have the background drug effect, but we also need to take account of the significant role of both restraint and exhaustion through struggling. So the factors that are relevant in a prone restraint death: the detainee already agitated and exhausted, heavily outnumbered by those restraining, struggling in resistance, prone position for much of the time, sudden collapse during restraint. And those are the sort of ingredients that you need to identify in a potential restraint-related death to make sure that you are not overemphasizing, if you like, any role for restraint. But if those factors are present, then there's a very real possibility that the restraint has made a more than minimal cause of death. So in conclusion, excited conditions must be treated as an acute medical emergency, and that's whether they're due to mental illness or drug-induced. It's no use just saying, oh, well, the person got themselves in that condition through drug abuse. That's not how we treat people. The prone position must be avoided if at all possible, brief as possible, and avoidance of prolonged struggling. Certainly, I've already mentioned the importance of avoiding any compression of the trunk, because probably being prone alone does not matter. It's a bit of additional compression of the trunk that really adds the danger. Thank you very much.
Dr. Cary, thank you for that. That was really informative. Please stay around because I do have some questions at the end. But for now, let me introduce Deborah Coles, who's going to talk to us about some of the work she's been doing, particularly in relation to restraint.
We need to hold those responsible to account because Thomas's life and death needs to matter. It has been truly heartbreaking to witness Thomas's hideous end. We can only imagine how dreadfully frightening it would have been for him. And we will never recover from this. We can never forget. And we feel almost as much victims of this as Thomas was. But to have some good come out of it, some accountability, some change in policy, some shift in police attitudes towards vulnerable people would go some way towards our healing. These are the words of the family of Thomas Orchard, who was restrained by police in 2012 when in a mental health crisis. Bound and gagged, his face and head covered with a heavy webbed belt, carried face down and left lying on the cell floor. Sadly, we are still awaiting the changes to the system his family desire. We know only too well that the system is defensive towards change and learning. What we need to grasp, however, is the psychological impact and trauma families experience when hearing about another similar avoidable death. Having expressed their hopes and often engage in change-making efforts, the hollow words of lessons will be learned show up the claims of transparency from institutions. They amount only to placations and in the system's failure to meaningfully engage in change. It only adds to the harm already done to bereaved families. I can't breathe, or words to that effect, have been the dying words of men, women, and children restrained to death crossing the 4 decades of INQUEST work. We will look at the patterns that emerge from deaths in similar circumstances of prolonged and/or dangerous restraint. While we say their names, remember their lives, and draw attention to the injustices of their deaths, we emphasize the loss and love of their families. We must confront that people have been denied a future, that avoidable deaths continue. As our systems fail to willingly address the harms that have occurred, fail to honestly admit to what went wrong, and thus are incapable of learning. This is unacceptable to bereaved families and should be unacceptable to all of us. We need systems that are willing to reflect, be accountable, and have a capacity and commitment for change. One of the ways the system implements this avoidance is by addressing these deaths as isolated individual incidents. This focus is used to avoid looking at their wider context, deaths across sectors and across time. INQUEST can clearly see the historic and systemic issues, the impact of structural racism and discrimination and other inequalities. Despite a pattern of restraint deaths where INQUEST juries have rejected the official version of events and found overwhelming evidence of unlawful use of force, neglect, and indifference, very clear human rights abuses, no police or prison officer or healthcare worker has been held responsible, either at an individual level or at a senior management level. Despite over 1,700 deaths in police custody and following police contact since 1990, there has never, as Leslie pointed out, been a successful prosecution of any police officer for murder or manslaughter. In 10 cases since 1990, murder or manslaughter charges have been brought against police officers. In all cases, trials have collapsed or officers have been acquitted by the jury. This is not, as the Police Federation said in their recent evidence to the Home Affairs Select Committee inquiry into police complaints, an example of how accountable the police are or the state is. Instead, it is about a wholesale inadequacy in the legal framework to ensure accountability, prevention, and change. 3 private G4S guards who restrained to death Jimmy Mabenga in 2010, ignoring his pleas that he could not breathe, were also cleared of manslaughter, a prosecution that was only brought after an INQUEST jury ruled he had been unlawfully killed, and that had exposed a culture of racism and violence within G4S and the privatized deportation industry. The risks of restraint were well known to G4S after the death of 15-year-old Gareth Myatt, who was restrained to death in a G4S-run child prison in 2004. State agents are rarely held to account, and this is one of the most contentious issues in relation to the approach of the criminal justice system to all deaths in custody. Bereaved families are being consistently failed and traumatized by an investigation system characterized by delay, denial, deflection, and defensiveness. At its core are concerns that the rule of law does not apply to the abuses of power or neglect of state agents in the same way as it does to an ordinary citizen. This serves only to create a culture of impunity which frustrates the prevention of abuses of power, ill treatment, and misconduct. The majority of information that has entered the public domain about restraint-related deaths has arisen only because of the deceased family and friends' full participation in the inquest proceedings, facilitated by their legal representation. In the absence of criminal prosecutions, the inquest is the only public forum in which these deaths are subject to scrutiny and where systemic failings and dangerous restraint techniques can be exposed. There is a shameful inequality of arms and resources at inquests, as Leslie's previous lectures have highlighted. It is a system loaded against victims and their families. From the failure to respect the right to life and dignity and respect of the victim is born another failure to uphold the right to truth and justice for their families. Speaking ill and blaming the dead and their families is a feature of so many state responses, from misinformation, demonization, and pathologization of the deceased as an attempt to deflect attention away from the role of the state and its agents. The narratives of the drug addict, the mentally ill, the gangster, the dysfunctional family, the othering. Part of the denial and deflection has also been seen in the role of competing medical theories to explain away and deflect attention from the central role that restraint has played in deaths. In the year 2021, it is beyond imaginable that after 40 years of inquest monitoring and analysis, we are in a position where this government and its institutions wants to deny structural racism is a problem and silence those making connections. It should not be a matter of continued contention that a disproportionate number of Black people die after the use of lethal force by police and neglect by the state. Unless we acknowledge this truth, we cannot work to address it. Deaths are at the sharp end of a continuum of racialized state harm that connects the Black community's broader experience of structural racism, over-policing, and criminalization. Use of force data in policing and prisons, along with disproportionate stop and search data, reinforces these racial disparities. This evidence shown in the criminal justice data is only one way structural racism shows itself. Working across decades with families, the patterns show us a use of racial stereotyping, equating Black people with dangerousness and criminality, portraying those who've died following the use of force and restraint as big, Black, and dangerous. In cases where people have had mental ill health, additional negative imagery and stereotyping is seen. The mad, bad, and dangerous. Attitudes and assumptions which have informed people's treatment. We know too of the high rates of restraint used in mental health and learning disability settings that disproportionately affects Black people, women, and children. These tropes, already woven so tightly into the mindset, culture, and practice of state agents and institutions, can lead to the disproportionate and fatal use of force. And as the deaths illustrate, these deaths disproportionately impact on racialized people and those with mental ill health. Structural racism and discrimination does not just occur in relation to individuals. Policies such as the war on drugs, being tough on crime, the war on terror and extremism, the hostile environment, the withdrawal of mental health support, of housing support, of drug rehabilitation, of welfare, as the state contracts its duty of care on the one hand, while expanding its punitive institutions. Racism and patriarchy are contemporary examples of a long-standing process of social objection in which certain groups of people are positioned as others, as disposable, less than human, reinforcing and reproducing the inequalities of power along gender, race, class, and disability lines. It is difficult to convey the shocking nature of evidence that comes out of inquests. What has happened to make our systems so intolerant to vulnerability? Revealing a use of force that is greatly disproportionate to the risks posed, especially where there is one person and a large number of officers. An obsession with dangerousness and ascribing agitation and disorientation as violence means the only available focus is the risk posed by the individual rather than consideration of their basic safety. Our son Shaney died because of the prolonged restraint in which he was held down by police officers while he was a patient in a mental health hospital. They held him face down, shackled with his hands in 2 sets of handcuffs and his legs in 2 sets of restraints. They held him down like that, in a prolonged restraint, which they knew to be dangerous, until he went limp. And even then, instead of treating him as a medical emergency, they simply walked away, leaving Shaney on the floor of a locked room, all but dead. That is how we lost our beloved son. These are the words of Shaney's family, who died under police restraint whilst medical staff stood by. The pernicious combination of such perceptions towards people of colour and those with mental ill health creates situations where the person being restrained is dehumanised, their life devalued. The frequency of comments made at inquests about the superhuman strength of people being restrained, the strongest person they've ever known, shields people involved in a death who are perhaps afraid or unwilling to recognise that the person who died at their hands was extremely unwell, in a state of crisis and highly vulnerable. Rather than working to get alongside the person in distress, what is demanded of them is compliance, sometimes to the point where eventually struggling ceases, a compliance that is never given, but forcibly taken along with their last breath and whole future. Not enough to demand their compliance so forcefully, the impact of this violence is often met with derision and disbelief that people are faking it. As Christopher Alder was left lying face down on the floor of a police station, officers laughed and joked at his expense. The question of people faking it has been heard at a number of inquests in the following years. Our casework suggests that when the use of certain kinds of violence is embedded in the working culture of any organisation, whether a prison, a hospital or the police, it isn't easily eradicated by directives from above. Too often we see state agents as the source of conflict and harm. Where there exist no real sanctions for those who abuse restraint and force, it is easy to see how those individuals working in detaining authorities are allowed to feel that they can act with impunity. The theory is that restraint is supposed to be deployed as a means of last resort, but a recurrent and fundamental theme that emerges in our cases is an all too immediate and easy resort to the use of force in general and restraint in particular among our detaining authorities, even where there are available and practical alternatives which are not considered. Regulations governing the use of restraint as a means of last resort appear enshrined only on paper. Inquest has observed a shameful lack of political will from the government to acknowledge, let alone implement, recommendations specifically seeking to address racism and discrimination in policing, health, immigration, and criminal justice systems. Recommendations echo recommendations after deaths in custody and detention, and across reports and commissions, reviews, parliamentary inquiries, inspections and investigations. This is again illustrated by the deaths of Sean Rigg, Shani Lewis, who I mentioned earlier, and Kevin Clark, 3 young Black men in a mental health crisis and restrained to death, under the care of the same mental health trust and the same police force. That these could occur over a period of 10 years illustrates starkly the failure of accountability processes to force the changes needed to prevent deaths. What we can say unequivocally is that had there been the learning and accountability from the deaths that came before them, their deaths might have, and indeed should have, been prevented. In 1999, Roger Sylvester, a Black man in a mental health crisis, died after being restrained by 8 police officers. His family faced a long and hard fight for justice, like so many families that came before and after them. The inquest into his death eventually concluded in October 2003, with the jury finding that the restraint was the cause of his death and that he was unlawfully killed, a conclusion subsequently challenged by the police. The coroner in Roger's case then produced a very lengthy Preventing Future Deaths report, which was 59 pages long, with 10 recommendations for the police and mental health services as to how these deaths could be prevented in the future. After the significant publicity surrounding his inquest, police forces became increasingly aware of the issues of ABD and positional asphyxia. There was another review into mental health and restraint by the Metropolitan Police Service in 2004, making another 26 recommendations, reiterating that if officers restrain a person who is having a mental health crisis, that person may die. Training and guidance were adopted. This, as Leslie pointed out, has been reiterated in other reviews and reports, not least the Angelini review, prompted by the deaths of Sean and Shani. In October 2020, the inquest concluded into the death of Kevin Clark. In their narrative conclusion, the jury described Kevin as a kind, gentle and well-liked person, known as a gentle giant by his friends and family. When he died, he was having a mental health crisis and was showing classic symptoms of ABD, such as those described earlier. He was compliant, but confused, in need of care and protection. Despite this, police officers took the decision to restrain him, while the ambulance crew failed to carry out a proper clinical assessment. Significantly, the jury at his inquest found that the restraint used by the officers was inappropriate and that it contributed to his death. And just like George Floyd and so many others, Kevin Clark was heard to say, "I can't breathe," while he was being restrained. The jury also found that opportunities for earlier, less restricted intervention were missed by the Mental Health Trust. Nearly identical findings of the jury at Sean Rigg's inquest. In short, the same things keep happening. We have known about this problem since the 1990s, and yet people are still dying. So what is needed to prompt the must-needed change? Inquest remains concerned that while shocking and contentious cases or critical reports may generate an immediate response and a commitment to change and learning, it is not sustained, does not become embedded in culture, approach and practice. Impotence and momentum is lost. with the risk that the same cycles are repeated. But INQUEST work makes it also clear that this is a public health and social justice issue. Yes, we need more de-escalation, more compassion and care. But ultimately, this is about the need to end the reliance on the police as the first responders to mental health emergencies. The police are not and never will be mental health specialists. It is not their function and does them a disservice to be mopping up the lack of public health resourcing. The government have announced 20,000 more police officers. Why not to redirect some of this money to establishing 24/7 mental health emergency response units? This service would not be made up of police officers. It would be made up of social workers, psychiatric nurses, and other professionals with appropriate skill sets. It would be focused on getting people the treatment and help they need, rather than on arrest and criminalisation. And projects like this are currently being trialled in a number of US cities. Such a service, if properly funded and resourced, and if staffed with appropriately trained and caring staff, could save lives. We also need to avoid people getting into crisis. Why is there always more funding found for increased police weaponry and more police officers, but not crisis cafes, safe havens, and crisis houses, and culturally specific community mental health services, providing an alternative to A&E or inpatient psychiatric admission or coercive policing, and properly funding and resourcing our existing mental health services and services that are run by and for the communities, which are stretched to the bone and starved of necessary funding after years of austerity. In response to the shameful lack of political will to enact change in response to investigations, inquests, and reviews, INQUEST have recommended a national oversight mechanism by which compliance with post-death actions and recommendations to learn from past errors are monitored, audited, and followed up. Potentially life-saving recommendations cannot simply be allowed to gather dust, and people need to be held to account for their implementation. This could also help those who want to try and drive change. The government has, sitting in its in tray, a series of recommendations about how to save lives and to deliver evidence-led policy. But instead, they choose to focus on preserving slave statues, rejecting data-driven policy and monitoring outcomes, and attacking critical race theory and Black Lives Matter. These are not encouraging signs for people concerned with improving the way public services deal with matters of racial justice and discrimination. This is about radical, transformative structural change and rethinking how we address societal harms and racial and social inequalities, that prioritizes people's needs and invests in communities. The very structural inequalities that have been brought into stark relief by the COVID pandemic and those who have died. These are conversations that have been energized by the Black Lives Matter protests and the campaigns of bereaved people. It is about how we think about safety in the 21st century. And rather than focusing on expanding the remit and resourcing of policing and prisons and coercive practices, the focus should be on investment in services that focus on harm reduction, drug, alcohol, mental health services, youth clubs and youth services, affordable housing, jobs, and addressing poverty and inequality. I'll give the last words to Sean Rigg's sister, Marcia Rigg, a formidable campaigner since Sean's death. We have to cling on to hope Otherwise, they've won indefinitely. And that cannot be right because the evidence is so compelling. It's traumatizing for any family, and I don't think that ever goes away. We understand that our loved ones will never come back. What we want is for it not to happen to another family. What we want is really effective change.
Thank you. Those are really powerful words that you concluded with from Marcia Rigg. Look, I really have to thank both of you for, really informative discussions on this really difficult and sensitive issue. But I suppose the question that I have is this: if you could change one thing to improve the system, what would it be? Nat, can I start with you?
Yes, so I think it's really the response to someone having a mental health crisis, the first response. So it doesn't really matter to me whether it's a drug-induced crisis or whether it's underlying psychiatric disease, or indeed a combination of both, which is quite common. And that first response could be picked up by 999 operators, and they need to direct it in a totally different way. This is an acute medical emergency. This is not to send a whole load of police along to hold someone down. It's an acute medical emergency. So mental health input, mental health nurses, the potential to escalate very quickly to psychiatry, and if you need to, putting someone in a mental health section. But the answer is not very severe restraint.
Deborah, in your discussion, you raised a really interesting point. I think I had touched upon it, which is we've got enough training. I often hear at inquests coroners making more recommendations for training. Is that the answer? Is it because these state agents aren't sufficiently trained? What's the answer? What would you suggest?
Well, I don't think it's a question of training. Absolutely not. The dangers of restraint are implicit in training and guidance and videos. So let's just be clear about that. As I said in my presentation, I think what we need to do is we need to redirect the significant resourcing that we put into policing into proper 24/7 mental health services, but also services in the community that can avoid people getting into crisis in the first place. So this is really trying to think about this in a more holistic way. And my fear is if we don't do something, these deaths will continue. And we know already this year, people have died as a result of being restrained by police. So let's look at this as a public health issue and not one about more coercive policing.
Well, that brings us to the close of this discussion. Who knows? Maybe police forces, prison services, psychiatric hospitals will take heed of this message. I just hope that we won't be back in 10 years' time still discussing the same issues that we were discussing 20 years, 30 years ago. Thank you for joining us. And can I thank both of my guests, Deborah Coles from INQUEST and Dr. Nat Cary, for joining me this evening.
Thank you.